Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and a big hello to everybody in between. My name is Dan Balkaran, as you can see on the screen, and I'm an employment lawyer at Samfiru, Tumarkin, LLP. As always, Canada's leading employee-side employment law firm. A couple housekeeping notes before we get started. As always, if you would like to reach us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 821-5900. Okay, please send in your questions sooner rather than later. We have half an hour for this broadcast. It goes by quickly. Quite often, get a lot of questions at the end, and I want to get to all your questions. They're great questions, and certainly I want to answer them all if I can. So please send them in. Okay, a bunch of questions just came in, so let's get started. I can't identify this person, so I'll just call him B, he or she B. If your workplace closes down, what obligations does your employer have, and do staff receive a payout if that happens? So anytime your employment is terminated without cause, you're entitled to, and that termination happens today, you're entitled to severance. Now, that severance can be as much as 24 months, depending upon what your employment contract says and your age, length of service, and position. The fact that your business is closing doesn't affect that ground floor termination right that you have. However, if the business goes bankrupt or insolvent, so insolvent simply means that it can't meet its liabilities and then can't meet its liabilities, and then it can seek creditor protection under federal statute. And if that occurs, you effectively do not have a claim, or more accurately, all claims that you have to money are stayed by legislation, and you can't bring them against the employer until the employer emerges from creditor protection. If the employer goes bankrupt, what happens is you then, as an unsecured creditor, have a claim on the existing assets of the business that are distributed amongst the secure shareholders first and then the unsecured shareholders after. Now, I've certainly assisted clients whose employers have gone bankrupt before, and generally speaking, you're not getting very much money. If there's a lot of assets, if the assets barely or less than the liabilities, and there's a bankruptcy situation, you might get 50, 60 cents on the dollar. But really, if your employer goes bankrupt, then you're looking at probably no money. So an operative question, if your employer is shutting down, is it just shutting down in your location? Are there still is the employer still going to exist in other parts of Canada, or does it still have assets in Canada that you know that you can claim against? You can have a situation where you have a great claim to zero. And if you are worried about that, if you're worried that your business or your employer may run out of money, certainly in any sort of negotiation for severance, you may be well advised to take a discount on what your best day of severance is. So complicated question. I gave you sort of a full rundown of possibilities in terms of my answer, but if that's actually happening to you, you should talk to an employment lawyer right away. And of course, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, as you can see on the screen, and 1-855-821-5900. Okay, question from Phyllis. My employer gave everyone new policy documents to sign regarding return to office with new terms of employment. Are those documents valid if we never received or signed them? This is an interesting question. Okay, so Phyllis, I don't know if you were subject to an employment contract before these policy documents. If you were, quite often employment contracts will say you're subject to company policies, which are these policies, and we reserve the right to update and change these policies as we go. and policies regarding health and safety or conduct in the office are distinct by degree from terms of employment. And so if your previous contract talks about, yes, you're bound by these policies and we can change these policies, arguably the employer can change the policies without providing you fresh value for the new contract and can just send them to you without requiring your signature accepting the new policies. However, if they're changing terms, because you said terms of employment as well. So terms of employment would be like pay, potentially what your duties are, termination clause, that's the big one, what happens to your entitlements upon termination. Lots of other things can be terms of employment, location, position, various restraint of trade clauses, lots of things can be in there. And so if they're seeking to change terms of employment, they can't do that. Your employer can't, or let me put that a different way. The document, whether you sign it or not, is not enforceable unless you're provided what's called fresh consideration. That's fresh value. In order for any contract to be valid between two entities, fresh value has to go in both directions. So when you originally signed a contract when you first started, it was job going one way and you're agreeing to be bound by the terms of employment going the other way. If 10 years later they want to change the terms of your contract, they can't just give you a contract to sign. That contract's invalid. They have to give you a raise or a signing bonus or some benefit. It can be very small, but there has to be some gain to you that you receive in order for that contract to be valid. So if there are terms of employment here beyond policy documents, policy changes, we'll say, then if you never received it or signed it, they are not valid, or they shouldn't be. But these are tough questions and they're very they're determined by what the facts are. And my 30-second answer is no substitute for getting proper legal advice, which I recommend you do if something turns on this. Now, regarding return to the office, I suspect what you're getting at is you work from home following the pandemic. Company now wants you to come back in on a hybrid or full-time model to the office. You don't want to do that. And you're asking whether or not, if you never signed that and never agreed, you don't have to return to the office. The answer is no. You're going to have to return. Like if you worked in the office before the pandemic and weren't hired remotely specifically in the pandemic, and the company says you got to come back to work, you have no legal right to not go to work. And so if the company changes its policy, you got to go back to work, you've got to go, or you've effectively, well, I guess you're committing insubordination, but you also might be abandoning your position depending on if you're still doing work from home or not. So if this is really a question about, do you want to, can you, because you didn't sign a policy document, disobey a direct order to come back to work? The answer is no. You'll be effectively guilty of insubordination and terminated for cause, which means you'll get zero severance. However, if you were hired specifically remotely for the pandemic and have never worked in the office, that's a different question, and certainly one that I encourage you to talk to a lawyer about as a potential constructive dismissal. And again, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But just to wrap up your question, Phyllis, or at least what I think is your question, you have no freestanding right to work remotely, work at home. I know it seems like it because we all move to working from home, but if your employer wants you to come back to the office and you worked there before, in the office before the pandemic and then move to remote because of the pandemic, you have to go back. Otherwise, you risk losing your job. I'm not going to use this person's name because it would identify them. If I do not sign an employment agreement, the company states that I'm resigning. Is that statement legal? Well, I mean, I don't think legal is the right question. The question is, if they fire you, are you entitled to? So I don't know if you signed a previous contract before this contract, and if you did, that contract may govern your employment. If you never signed a previous employment contract, you are entitled to what's called common law severance upon termination. It's actually common law notice, but if they terminate you today, it converts into severance. And notice is just simply a heads up. Hey, you're going to be terminated in 6 months. You've got to work out those 6 months. We'll give you a paycheck for 6 months. We'll give you time off to look for another job, and hopefully you're not unemployed for very long, if at all. That's what you're entitled to at law. However, if you are terminated today, those, for example, 6 months that you were entitled to in notice, but can't work because you're terminated today, they convert into money. The money that you would have received had you worked those 6 months. The money that you receive for not working your notice period is called severance. And so severance and notice are interchangeable as far as the calculation is concerned, but your legal entitlement is to notice. I'm going to call it severance for the rest of this broadcast because everyone understands intuitively money for termination. Okay, so company says you got to sign a contract, and if you don't, you're resigning. Okay. If you've never signed an employment contract before and you're terminated today, you get common law severance, which again can be quite lucrative. It can be as much as 24 months, depending upon your age, length of service, and position. So, but in the employment contract, but if you don't sign this employment, let's just say this employment contract, I suspect contains a termination clause that limits your severance upon termination to something small. If you don't sign it, the company can fire you, but then you're getting, and probably will fire you, or will seriously think about firing you, but your severance is not limited. If you never signed another contract, your severance is not contractually limited, and you get common law severance. But you need to know what that is. If it's 2 months, probably be better off signing the contract. But if it's 15 months, you'd be better off not signing the contract. So certainly, perhaps more than everyone else, I've every question I've answered today, you need to talk to an employment lawyer immediately. To your second point, company states that you're resigning if you don't sign the contract. Resignation, that's not a resignation. You saying I'm going to continue to work here, I have no intention to resign, but I'm not signing your contract, is not a resignation. And if they construe it as a resignation, they will in fact be terminating your employment. So either the real question is, should you refuse to sign it? Because if you refuse to sign the contract, you are facing perhaps, likely, or maybe not likely, but potential termination, certainly creating bad will within the business, and you may not have a viable career there for very much longer. And so you need to know what your termination rights are now pre-signing that contract, which means you need to talk to an employment lawyer right away. You can talk to us if you'd like at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay. But just be aware, sorry, just a final thing. If you don't sign it, it's very likely you won't have a job. So you need to make sure that there's enough value for you to risk that. I'll just leave it at that. Pardon me. Question from, I don't know, I'm going to say Robert. I was just let go from my job after 17 years of the company. No warnings or reasons other than the market is difficult. Yeah, this might be something that comes up more and more in the economy, given the challenges that the Canadian economy is facing right now. I was offered 15 weeks of pay and wondering if this is enough. Considering the job market right now, should this be more? So again, it depends what your employment contract says. Your employment contract may limit you to as little as 8 weeks of pay if you're provincially regulated. But the fact that they offered you 15 weeks of pay implies maybe your employment isn't subject to an employment contract limiting your termination rights. If that's the case, you may have a high watermark of 17 months or so of pay. So Robert, you need to talk to an employment lawyer right away to get an assessment of what your actual legal position is and your high water mark for severance, so you can understand how you need to pursue your negotiation. I just gave everyone the information for contacting us. I'll hold off on doing that. I'll give it to everyone later. But Robert, you need to talk to an employment lawyer immediately because it could be that you're entitled to a lot more than that. And just for everyone else, and for Robert, so if you have no employment contract, the amount of severance you're entitled to, you get common law severance, as I said, and it can be as much as 24 months. The quantum of it is an assessment of your age, length of service, position, and availability of similar employment. But maybe not the most important one, each one matters, but the one that really moves the needle is length of service. If you're a 3-year employee, you're going to get substantially less service than if you're a 17-year employee, severance, than if you're a 17-year employee like Robert. And so those 4 factors will be, but if, for example, you have a disability that prevents you from getting a job very quickly, that could also add a substantial amount of time to your severance. Or if you were a very high-ranking, in a very high-ranking position, like an executive, that can add. Or if you're quite a bit older, from an employment perspective, you're 68, that can add a lot to your severance. So it's no one factor is determinative, but usually the most important is length of service. Robert here has 17 years of service. So if he has no contractual language limiting his severance to something smaller, he could be looking at quite a bit of severance, as I said, around 17 months or upwards of 17 months. But that entitlement is not unfettered. It's subject to his making reasonable efforts to look for replacement employment. And if he finds a new job, he's not entitled to double compensation. So any money he makes in a new job is deducted from his severance claim. So even though his high watermark is 17 months, the fact that he's got to look for another job combined with he's not entitled to double compensation, if he finds a new job, acts as a discount function on your best day. So even though your best day is 17 months or 18 or whatever it is, if you can get a settlement for somewhere south of 17 months, but at a reasonable number, you're probably incentivized to take it. So depending, again, on the situation. But yes, Robert, you should talk to an employment lawyer right away. Again, I can't identify this person. He was let go on December 24th after 2 years and 10 months of employment. He was offered 2 weeks notice plus 3 weeks of severance pay. I was retained on merit in September for 23% hike after I got job offer from other employer. I have no idea what you're saying. I don't know what your question is. And I'll invite you to resend in a new question. I don't know what I was retained on merit in September for 23% hike after I got job offer from other employer. What are my options? I don't know what you mean. So please send a question, a clarification of your question. Never seen this question before. Francine asks, can you be terminated on the balance of probabilities? I'm going to need more than that, Francine. I have no idea what you're referring to, but I will say this. Balance of probabilities is a legal term referring to the standard of proof. So everyone has heard criminal law, beyond a reasonable doubt in the media. That is what a jury or judge has to get to in order to achieve a conviction in a criminal case. In a civil case, which is what all employment severance matters are, okay, where you're pursuing a claim for additional money from your former employer, if it were to get to a hearing, the standard of proof is not beyond a reasonable doubt, which is almost 100% certain, but not quite. Balance of probabilities is just 50% plus 1, more likely than not. Okay, that you're entitled to, or that you were wrongfully dismissed for most of you. Terminated on the balance of probabilities, I suspect what happened is someone or your employer was accusing you of something, some sort of misconduct or performance issues, and they didn't have all the evidence to say for certain that you did commit, whatever the accusation was. And so they said, but, we find it more likely than not that on a balance of probabilities, you did some of these things and therefore we're terminating you. I'm guessing that's what you're asking, but if you could clarify, I'll try to answer your question. We've only got a few minutes left, so you can get your clarification in soon. But to sort of surface answer your question, I've never heard of that, Francine. Okay, we only have 2 questions left, and we've got 7 minutes left. So if there are any more questions, please send them in now. Okay. Do you think there'll be some sort of allowable layoffs for employers as a result of the trade issues with the U.S.? Okay, so the way the law is currently structured, if a business is being affected by the tariffs such that their revenue declines and they have to let people go, those people are entitled to severance, as I've been discussing throughout this broadcast, without any reduction in entitlement. Now, if the problem becomes significant enough in the economy, I could see some provincial governments stepping in and saying, okay, the way that most businesses are going to deal with, because they don't want to lose the employees and the employees don't want to lose their jobs, but there's a great deal of uncertainty around how long the tariffs are going to last, what their impact is going to be. Will there be some sort of deal between the two countries that allows the tariffs to come off? We just have no idea. And so I could see a situation very similar to the pandemic where legislation comes in from provincial governments that does something like extend the time that an employer can lay off an employee without that employee being automatically terminated by operation of statute, usually the Employment Standards Act. So, for example, in BC, very similar to the pandemic, in BC, during the pandemic, after 13 straight weeks of layoff, your employment is, at least as far as the Employment Standards Act is concerned, your employment is terminated by operation of law. And so what the provincial government did was extend that twice, I believe it was twice, 2 or 3 times, to run effectively from about March 20th, 2020 to about August 30th, 2020, and then no more. And if an employee was still on layoff after that time, they'd be terminated by operation of statute. But it provided a longer window in which those employees could, or those employers could recall their employees back to work without triggering a termination and potential severance claim. And so I could see something like that happening, depending upon the impact. So the pandemic was economy-wide, whereas these are targeted tariffs in certain industries. So I can't see, unless the impacts get significant across the economy, I can't see the government stepping in yet, but that's really more of a political question than it is a legal question. But the mechanisms for doing what you're saying were already explored during the pandemic, and so I could see some sort of piggybacking off of that. But again, that's more of a political question than a straight legal question. The legal answer to your question is there's no right at law right now to reduce your severance entitlement upon termination as a result of tariffs. But if you're placed on layoff that you consent to and you're provincially regulated, you'll remain on layoff for at least the period of time specified in statute, at which point in time you'll most likely be automatically terminated, and then you have severance entitlements. So we just don't know anything yet, but certainly perhaps the government will act, depending on the severity of the impact in the economy. Renee asks, should you ever sign a full and final release under no circumstances? Is that always, I don't understand how those two things are together, but is that always bad news? Listen, if you are A full and final release is something that effectively says you have no claim against your employer forever for matters arising from your employment. It precludes you from filing a court claim against your employer or any sort of other claim for money that arising from your employment with the employer. And so the employer, generally what's going to happen is when you've terminated your employment, the employer will pay you the statutory minimums and then offer you an additional amount in exchange for a signed release. They will not give you the money without the signed release, and they are buying it's a contract, money for release. And the release prevents you from suing the employer ever again, but it'll also probably tie you down to confidentiality, non-disclosure, and some other things. And you are completely bound by that document. So you need to make sure before you sign a release that the amount of money you're being given is fair and reasonable. Because if it's not, it doesn't matter. You can't go back and undo it. So before you ever sign a release, talk to a lawyer. I'll post my information at the end, not my information, my firm's information at the end. Question from Gus. I have to travel overseas to deal with some family issues. In the summer, I will need at least 4 weeks to handle everything and have requested to take unpaid leave for this because I only have 3 weeks of paid time off. My employer said that my unpaid leave request is considered a resignation, and when I return, I have to reapply. Is this accurate? What are my rights? Well, really, you're asking for a 3-week vacation and a 1-week unpaid leave, right? Your employer may be right. You've asked permission to take this time off. They've said no. If you just do it anyway, is it a resignation? Well, I mean, it's you have to intend to resign, and you clearly don't intend to resign, but you have an obligation to be at work when your employer says you should be at work. And it's more job abandonment, actually, for slight distinction, but I think you need to work this out with your employer. I don't think this is something you can risk. I see this from time to time. I'm sorry you're encountering this, but you don't have any leeway under any law that will allow you to leave for 4 weeks. Now, if your employer will give you 3 weeks of vacation and then you ask for 1 week of unpaid leave, maybe they'll do that. But you need to talk to your employer and try to sort this out. You could try to appeal to the when you get back to the sort of the heartstrings of the court. But I think you've said I need this time off. They've said no. You do it anyway. If it's not approved and it's clear that they haven't approved it, you're probably abandoning your position. So you need to work this out with your employer if you can. Can an employer terminate you for following your manager's instructions? Your employer can terminate you for anything. Pardon me. Your employer can terminate you for any reason. They just have to pay you the right amount of severance when they terminate you. However, can they terminate you for just cause and pay you 0 severance? No, you're going to get severance. But again, it depends how much severance you have coming to you. If you have 24 months of severance coming to you, that's a different matter entirely than if you have 2 weeks. So I'd talk to an employment lawyer right away. Okay, I'll just see if I can get through these really fast. A whole bunch of questions came in. I already answered that question. I was retained by my employer after I told that I got another job offer. Company asked me to stay back. I would have taken that job. I would have a job. I still don't understand what you're saying. I'm sorry. I won't be able to answer your question because I don't know what you're asking. Francine's back. That's it. False allegations and harassment from the employer. Hostile workplace. I've documented all harassing behavior from my employer for 2 years, including health and safety issues. So you're both accusing each other of being the problem, Francine. And the question is, did they terminate you for just cause and provide you with 0 severance, or did they pay you severance? If they paid you for if they provided you with severance and terminated you without cause, your only real operative question is, how much did they give you the right amount of severance? And you need to talk to a lawyer to find that out. However, if they terminated you for just cause, Then you've got to win on the issue of just cause, and then you've got to, and then there's the quantum for your severance. So you should talk to an employment lawyer right away. But it sounds like I correctly guessed what it was that they were saying, which is they alleged misconduct in your part, but they couldn't quite prove it. So they said it's more likely than not on a balance of probabilities, which will be very challenging for them if it's a just cause termination. So I would encourage you to talk to an employment lawyer right away. And last question, if your employer rejects your claim for disability accommodations, is that legal if you have a note from your doctor? That's too, I unfortunately, I won't be able to answer that question. Join us on Monday and ask that question, because that's going to be a longer answer. You can see on Monday, we've got Chris Justice coming in on March 17th at 1:30 p.m. He'll answer all of your questions. For all the people that I said to talk to a lawyer, if you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Thanks for your great questions. Have a wonderful and safe weekend. I will see you back here in 2 weeks during my regular 10:30 Pacific time slot. Otherwise, have a great weekend and join us on Monday at 1:30 p.m. Eastern Time with Chris Justice.